So good afternoon, everyone. Welcome back to our weekly webinar series. Today we have a very interesting topic where we will be going through various SARFAESI related judgments, DRT related judgments that have been delivered by Honorable Supreme Court and various high courts of India. Many of these judgments also have implications and interpretations with respect to how charges or first charge, second charge is recognized. And that is also something which is very, very important for all of us to understand whenever we are taking care of insolvency as well. So we have with us today Anil sir, and we also have Sanjay ji and Anil ji. All of us are of course partners at AAA. Sanjay ji is also taking care of the SARFAESI business at AAA. Over to Anil sir.
Thank you, Ankit. Namaste and good afternoon to all the participants. As usual, whatever we do, we try to change our program so that we reach home by 1 o'clock. I still reach home within 10 minutes, but we can start wherever we are. So we have Mr. Sanjay Gupta today with us, who is the director and CEO of AAA Capital Services Private Limited. AAA Capital is the largest company in India as resolution agents, enforcement agent, and supporting agency for SARFAESI cases. So SARFAESI is where any asset is mortgaged, and our role is, which is outsourced to us by the bank. Our role is to start from the notice, then start from the symbolic possession, identification of property, going forward, then the application to CMM, DM, Deputy Commissioner, GMM for taking possession of the properties, taking police help, then providing security when we take the physical possession, finally finding a buyer and sale. So for this scope of work, AAA Capital Services has been given more than 30,000 cases so far in the last 19-20 years, because we started in 2003. So AAA Capital Services is empaneled with almost all the banks in India, and we have more than 225 human resources full-time working for this. Therefore, SARFAESI is very close to our heart. Sanjay ji will add his practical experiences in SARFAESI matters. And like whenever we meet banks, bank normally ask us after the IBC, what is the status of SARFAESI? So we are saying that the SARFAESI has a separate role in the recovery process, whereas IBC is definitely a resolution for companies under stress. For SARFAESI, unless the company goes NPA, becomes NPA, SARFAESI law is not applicable. Whereas in IBC, it is only a matter of default. If there is a default, then the insolvency can be started. SARFAESI can only be used by banks or some NBFCs or ARCs, whereas the insolvency can be used by workmen, employees, operational creditors, government dues. Any kind of creditor can use IBC. So some of the very important judgments on SARFAESI that in fact was delivered in last 1 month was very important, but even prior to that, we have certain orders. So Sanjay, I think the first one, which is very, very important, is I have the first judgment that we are now trying to, I'll just share my screen. Give me a minute. So we have in fact kind of 6 judgments, and I think the first 4 judgments are from Honorable Supreme Court. The rest of the judgments are from high courts, but important judgments. So we actually I think there is a slight difficulty in this. Let me check. Let me check. So this is the judgment which is very important. Balkrishna Rama Tarle, who was actually dead, but this was the case through their legal representatives, versus Phoenix ARC Private Limited. And this judgment was delivered on 26th of September 2022 by Justice Amar Shah and Justice Krishna Murari. So very important facts of this case is that one, that I would tell you that this, of course, this is something which is slightly different, that Ralliger sanctioned a loan of 6 crores and then it was assigned to ARC, default happened, and the Sarfaesi section 13.2, and the finally the after the assignment, Phoenix ARC became the symbolication was also taken under section 13 subsection 4, and the application was filed before the district magistrate under section 14 for taking physical possession of the secured asset. The district magistrate DM declined to provide physical possession to the secured creditor in taking possession, and the DM observed that there is a tenancy in the premises which is mortgaged, and DM also observed that the tenancy is even before the mortgage was created. Even before the mortgage was created. Now, this is a settled issue that the tenant cannot be evicted under Sarfaesi Act, because the whatever title of the property will pass on to the financial creditor, secured financial creditor, that will also go along with the tenancy right of the tenant. Now, the DM said that till this termination of the tenancy right is pending, which is a normal, after following a due course of law, the DM cannot assist you. The DM, therefore, it's a restricted kind of provision that I would not say that then finally what happened, the secured creditor, means the Phoenix ARC, they filed a writ petition before High Court, whereby the ADM was directed to dispose of the application under section 14. Now, the High Court also observed that the ADM is simply providing a police help, simply providing a kind of physical possession of the property, and the High Court also said that the third party petitioner claiming to be tenant in some of the secured preferred the present special appeal. So High Court also said that the ADM has to give an order. Now, next is what is the issue? The issue is involved whether during exercising power under section 14 of the Sarfaesi Act, the district magistrate or designated authority can pass such order that unless and until the secured creditor terminates the tenancy rights of the third person by following due procedure of the law, and further orders regarding possession of the mortgage property, only then an application under Section 14 of the SARFAESI Act will be decided. Now, the petitioner said in the High Court that the High Court ought to have appreciated that the tenancy was subsisting and continuing since prior to the mortgage of the property, and therefore their rights are to be protected, and unless and until the proceedings are initiated for eviction of the tenant, the secured creditor who will be in shoes of the original landlord cannot get possession in an application under Section 14 of the SARFAESI Act. This was the petitioner who actually said in the court that it is a difficult scenario. We are tenant and we cannot be evicted. Now, in this scenario, we also would like to see what is the law. These are the slides where we are saying that what exactly is the law. These are, of course, some different slide, but then this is also a different slide. Anyway, this is not relevant today. So we now go to the decision of the Supreme Court. Now, the Supreme Court says in this case that the CMM or the DM to immediately move into action after receipt of a written application under Section 14, subsection 1 of the SARFAESI Act from the secured creditor for that purpose. As soon as application under Section 14 is received, the CMM/DM is expected to pass an order after verification of compliance of all formalities by the secured creditors referred to in proviso in Section 14(1) of the SARFAESI Act, and after being satisfied in that regard, to take possession of the secured asset and documents relating thereto, and to forward the same to the secured creditor at the earliest opportunity. Once all the requirements under Section 14 of the SARFAESI Act are complied with, satisfied by the secured creditor, it is the duty upon CMM/DM to assist the secured creditor in obtaining the possession as well as documents relating to the secured assets, even with the help of any officer subordinate to him or with the help of advocate appointed as advocate commissioner. Under the circumstances in the present case, no error has been committed by the High Court in setting aside the order dated 27th of August 21 passed by the designated authority, keeping the application pending till the secured creditor initiate the legal proceedings for eviction of the tenant cannot get possession in an application under Section 14. Now, what happens to the legal tenancy rights? So what I understand is that the Supreme Court has just said that it is not the duty of the CMM or DM to see whether the possession can be taken or not. The DM should not have passed that order. The DM should not have passed that order. The DM should have taken the possession and handed over to the secured creditor. That's what the Supreme Court says. However, before that, there are many judgments which says that the tenancy rights would survive if the tenancy is genuine and if the tenancy is bona fide. So this is the first judgment which has come, which says that the tenancy, even the tenant, the DM has no authority. So what I understand is that this particular judgment is focused on that the DM should pass an order for the eviction of for the taking possession. Now, when the DM starts, when the possession is being taken, the DM has no role in this regard. However, I feel that the tenancy rights are still protected. Maybe that the DM doesn't have a right to adjudicate. DM only has a right if the property is mortgaged. The DM should help the secured creditor. DM should take the possession and hand over the property to the secured creditor. This is what I understand. But now I think we can take the views of Sanjay Gupta and Ankit Goyal, because like there are many judgments which say that the tenants are protected. In this case, it says that the DM has no right to check, has no right to adjudicate. The DM's role is only to take the possession and hand it over to the secured creditor. What do you say, Ankit? What do you say?
So this order, of course, is mm, indicating that the DM should not do that. Now, but at the same time, let me try and share this section 17. I'm not sure if the Supreme Court order has talked about section 17. Section 17 4A says this is a section which is application against measures to recover secured debts. So there it says that where any person in any application under subsection 1 claims any tenancy or leasehold rights upon the secured assets, the debt recovery tribunal, after examining the facts of the case and evidence. So I think the law is very clear in 17(4)(a) that the matters with respect to tenancy have to be dealt with by the DRT, and the DM is not the authorized person to determine tenancy or satisfy tenancy. 4A, section 17(4)(a) is very clear that the jurisdiction is DRT's.
Yes, one more point, Ankit, that the Supreme Court in this particular order has categorically mentioned and said that CMM/DM is not required to adjudicate the dispute between the borrower and the secured creditor and or between any other third party and the secured creditor with respect to secured assets and aggrieved party to raise objection in the proceeding under section 17 of the Sarfaesi Act, as you rightly mentioned the sections, before the debt recovery tribunals. So one more point which is important to note here, that the petitioner has claimed that this tenancy is prior to the mortgage of the property. So 2 points have been well clarified by the Supreme Court, that mortgage, even if it is prior to the mortgage, so it is not to be adjudicated by the DM/CMM. And secondly, they have the right to go to section 17, but CMM/DM cannot hold the issuing of this order under section 14. So they have to issue the order within the time-bound manner. So this is an important judgment. Practically, we see in many places of DM give the stay, maybe because of some representation made by the said tenant, or maybe on the ground of some stay they took from the local civil court on the same basis, on the basis of the tenancy, even if the bank is not party to that order also in the civil court. So even then they go to the court and give their objections, and DM doesn't give that order. So that this judgment is particularly very helpful for speeding up this issuing of section 14 under Sarfaesi Act. So this is a very good judgment. Yes, sir.
Observations that we can finally make. One, that the DM has to decide about the tenancy or not. The tenant should have gone to DRT, whether the tenancy is right or not. Is it okay, Ankit? Because the tenant should have gone to DRT for any eviction application. The jurisdiction is with the DRT.
So now I think all the high courts, all the Supreme Court also in this judgment, there have been so many judgments now where the DM and CM are only supposed to check the documents, whether the documents are in place in the application made before them. And it is now almost clear that there shouldn't be any hearing, there shouldn't be any representations. All they need to do is look at the documents and provide support services or support to the borrower, to the lender, to take over the possession.
There are two aspects, sir, in this regard with regard to tenancy. Number one, as the court says that we cannot give the order due to non-termination of this lease. So for this, the secured creditor maybe or the actual landlord should have gone to the relevant tenancy act to get that tenant evicted. Secondly, if the tenant is aggrieved or somebody occupier is aggrieved, they should go to the DRT under section 17 to get the relief under eviction order by a secured creditor. So actually DM is not here to see this kind of dispute. So this is Supreme Court saying.
So what exactly we are trying to say, that the tenancy is still protected. The tenancy disputes has to go to DRT. The DM or CMM has no power to adjudicate this issue. DM or CMM, they actually have to see the documents, and in case the documents are complete, they have to simply take over the possession and hand over. So it is up to the tenant to go to other court or go to high court or go to, so that the actual decision is taken on the bona fide of the tenancy. Is that okay? I think we can move forward.
Yes, sir.
I think there was one good thing that I thought that I would read. That was the, but then I couldn't find in the, because that was in fact very good. What exactly is the law? That was in fact very good. So if I can still find that, because see, I actually wanted that should be discussed in the meeting.
Should we now move to second judgment?
I see this what I just wanted. What is the law regarding? So when we see this section 14, which is regarding the CMM or DM to assist secured creditor in taking possession of the secured creditor. This is the text of the law, SARFAESI law, section 14. It says that where the possession of any secured assets is required to be taken by the secured creditor, or if any of the secured asset is required to be sold or transferred by the secured creditor under provisions of this act, the secured creditor may, for the purpose of taking possession or control of any such secured creditor, request in writing the CMM or the DM within whose jurisdiction any such secured asset or other documents relating thereto may be situated or found, to take possession thereof, and the chief metropolitan magistrate, or as the case may be, the district magistrate, on such request made to him, take possession of such assets and documents relating thereto, and forward such assets and documents to the secured creditor. And now this is also important, that provided that any application by the secured creditor shall be accompanied by an affidavit duly affirmed by the authorized officer of the secured creditor, declaring that. Now the contents of the affidavit is a kind of guidelines, and the content of the affidavit is a part of the SARFAESI Act. Now when we read this affidavit, each and every paragraph is actually putting a responsibility on the secured creditor, either to satisfy DM, CMM, or to submit a document in this regard. So after this affidavit has come in the law, I think it was also inserted in 2016. Now it is very clear that what an application for DM or what an application for CMM should include, what documents and what kind of duties that the CMM or the DMM has. So in case we read this affidavit, I'm not spending time on this, but I'm only trying to say that if all these documents are provided, then the DM is supposed to give this, supposed to do his job within 30 days, or supposed to give an order within 30 days. And in case he is not able to do this, and then maximum by 60 days by recording reasons of not being able to give so. So this is something that I wanted to share with you, that the law has actually become now a little easier with this affidavit, So I think we can move on to the next judgment, which is RD Jain and Company versus Capital First Limited. The judgment is from Honorable Supreme Court and it is dated 27th of July 2022. Now, in this case, this secured creditor instituted proceedings under SARFAESI Act for recovery of amount payable by the appellant borrower and to take possession of the secured assets. Borrower refused to hand over the physical possession of the asset. Therefore, the secured creditor filed an application under Section 14 of the SARFAESI Act with the learned CMM code, praying for assistance in taking physical possession. Now, the said application was adjourned time and again. Upon filing application for advancement of the date, the learned CMM dismissed it, observing it is application is a fresh application and many old applications are already pending. Now, what happened in this case, since the CMM was having a lot of pendency, the secured creditors submitted an application first and then filed a fresh application saying that my case should be heard because it is pending for the longer period. Then CMM passed an order and rejected that application, that the application for advancement of date is rejected. It was dismissed because the CMM says that I have many older cases and it is not possible for me to do this advancement of date. Now, against that particular application, the secured creditor approached the Honorable High Court by a writ petition for an appropriate directions to CMM to dispose of the case applications under Section 14. Now, Honorable High Court opined that considering the volume of the applications filed under 14 of the SARFAESI Act and pendency of such application, the learned CMM, who is an authority under Section 14 of the SARFAESI Act, cannot decide such application within a time-bound period in terms of the first and second proviso to Section 14(1) of the SARFAESI Act. High Court further observed that and held that as the status of learned CMM and assistant CMM is same and identical, the ACMM can exercise the powers under Section 14 of the SARFAESI Act, and while interpreting Section 14, SARFAESI Act was held that DM CMM is not a persona designata for the purpose of Section 14 of the SARFAESI Act. The expression DM and CMM as appearing in Section 14 of the SARFAESI Act shall deem to mean and include ADM and ACMM for the purposes of Section 14 of the SARFAESI Act. The SARFAESI Act. The borrower has preferred the present appeal. Now, in this case, the High Court observed that if the DM or CMM doesn't have time or he is over-occupied, then these applications can be handled and disposed of by ADM and ACMM. So, Sanjay, what is the present position? How many districts you feel that the CMM or the DMM have given the authority to their ADMs or ACMMs? What is the kind of your experience? Because see, you deal with almost the entire country. Where all the ADMs and CMMs have actually been given power?
Sir, I think in more than 50% of districts, they have already delegated these powers to ADM, ACM, etc. Because there was amendment in this act that DM can delegate or DM can take possession and authorize some other person subordinate to him for taking the possession. So since the last 3 to 4 years, these powers have been delegated, and we have to go to ADM courts, ACM courts, CGM also. Last year, this judgment also came that CGM is also equivalent to CMM and DM with respect to SARFAESI Act. So CGM is also handling these cases. So all these courts have been delegated by the designated authority, that is DM and CMM. More than 50% or 60% we are coming across these courts, subordinate courts.
So in this case, being a creep, the borrower observed that the above ruling of the High Court, the expression DM and CMM as appearing in Section 14 of the SARFAESI Act shall deem to mean and include additional district magistrate and additional chief metropolitan magistrate for the purpose of Section 14 of the SARFAESI Act, hence filed the appeal before the Supreme Court. Now let us see what Supreme Court says. Very clearly, Supreme Court says that the impugned judgment of High Court is just contrary to the decisions of the Gujarat High Court, Kerala High Court, and Kolkata High Court, whereby it is held. Number one, DM and ADM are two different and distinct authorities. Powers conferred on DM or CMM, as the case may be under Section 14, are inter alia, that the powers are conferred specifically on these authorities. One of the aspects of the power to be exercised is that the DM or CMM has to satisfy himself about compliance of the requirement of the section. The satisfaction is personal satisfaction. They themselves only are the competent authority to exercise the powers. The nature of powers under Section 14 would not permit transfer, delegate of exercise of the power under the said provisions of to different person or authorities. Prayer for dismissal of appeals, stating that as per Section 14 SARFAESI Act, the applications are to be decided and disposed of within a period of 30 days. However, looking into the volume of work and applications pending for the DMM, CMM, along with the duties like administrative work, and with a view to see that ultimate object and purpose of providing the timeline in deciding the application under Section 14 of the SARFAESI Act, the present appeal shall be dismissed. Now, further contentions which was made, it is very important that we should see what all was said by the applicants or the respondents. Further contentions were made before the Honorable Supreme Court that Section 14(1) capital A has been inserted, by which now, while exercising the powers under Section 14 of the SARFAESI Act, DM or CMM may authorize any officer subordinate to him to take possession of such assets and documents relating thereto, and to forward such assets and documents to the secured creditor. Now, Section 14 of the SARFAESI Act predicates that if the secured creditor intends to take possession of the secured creditor's secured asset, must approach CMM DM by way of an application in writing, and on receipt of such request, CMM DM must move into action in the right earnest. Possession of the secured asset can be taken by a secured creditor before confirmation of sale of the secured assets, as well as post confirmation of the sale. The ACMM can be said to be at par with CMM insofar as powers to be exercised under Criminal Procedure Code are concerned. CMM, in addition, may have administrative powers, however, for other purposes, and more particularly the powers to be exercised under the Criminal Procedure Code, both are at par. Therefore, the ACMM cannot be said to be subordinate to CMM insofar as exercise of judicial powers are concerned. CMM DM has to act within the stipulated time limit and pass a suitable order for the purpose of taking possession of the secured asset within a period of 30 days from the date of application, which can be extended for such further period, but not exceeding in aggregate 60 days. Thus, the powers exercised by CMM DM is a ministerial act, and he cannot brook delay. The expression CM Chief Metropolitan Minister is appearing in Section 14 shall deem to mean and include additional Chief Metropolitan Magistrate for the purpose of Section 14 of the. So the three things: one, that it is the duty to provide such help within 30 days or maximum by 60 days. In case the CMM or DM is occupied, then the matter can be handled by additional CMM or additional DM. So presently, Sanjay, what is the kind of, still you feel that there are some states who are not supporting the timeline of 30 days or 60 days?
Yes, sir. There are many states that they are not respecting these timelines due to all these practical difficulties mentioned in this particular judgment, maybe volume over volume, and they are handling the cases themselves, not delegating. One more practical point, sir, is mentioned in this judgment that before the possession of the secured asset can be taken by the secured creditor before confirmation of sale as well as post confirmation of sale. So this is also a important practical point taken very well by the Supreme Court. In some cases, we see that DM rejects this application that the property has already been sold. So you have to come to us before the sale, sequence wise, you have to go according to law. So all these and the 30 days, 60 days is also very well clarified here. So practical difficulties, I think they should be reduced after this judgment. But yes, delay is there in many of the other 50-60% of the, but there is definitely a speed up if we compare before 2-3 years back and in this year. So there is we see a speed in it, but not to that level.
So I think most of the hurdles are over now, but this tenancy used to be a hurdle always, and it is still a hurdle. I am not sure whether this particular judgment will help the tenancy disputes, because it is already held that the tenancy disputes would be handled by DRT. I think this judgment is focusing on whether the CMM DM has the power to adjudicate that issue or not. I think this issue is also clarified that there are some banks, some secured creditors, they are selling the assets after taking the symbolic possession. And once they sell the asset, they confirm the sale, then they file an application for taking physical possession of the property under Section 14.
Yes.
So Ankit, any questions are coming or anything which is coming in your mind regarding these? Because we have handled these two. One is tenancy, one is the 30 and 60 days timeline, and also whether this subordinate officer issue, that is also very clear that it can be handed over to subordinate officers.
Yeah, I think no further observation. I think we should proceed forward. We are running short on time, so
Okay.
we can try and cover up on the time. No questions also from the audience.
Okay, we're moving forward. Another Supreme Court judgment in the case of NKGSB Cooperative Bank Limited versus Subir, Chakravarty and others. And this was the judgment given by Honorable Supreme Court in February 22. The matter was basically challenged because we have seen even in Delhi, the CMM has a tradition that whenever we file an application after hearing, the advocates are appointed as commissioners. And the role of the advocate is that the advocate will go along with the secured creditor or their appointed authorized agents. The advocate will go along with the police, and the advocate will work as a commissioner on that particular process of taking over the possession. This appointment of advocates as commissioner, Sanjay, how many states presently or how many districts they have this kind of process where they appoint the advocates as commissioner? rather than appointing ADM or ACJMM, they appoint advocates as commissioner. How many states are actually doing this practice?
Sir, in metropolitans where there is a CMM, so they are having the practice of appointing these advocates as commissioner. Delhi, Bombay, maybe Kanpur, wherever there is a CMM. So that way, Delhi is appointing the advocates since a very long time. So it is a very fast process here in Delhi. Delhi judiciary is going very well. Other where there are DMs, so they have a practice of directly appointing the police or directing their authorities, maybe Tehsildar, Naib Tehsildar, ADM, SDM, Patna, Bihar, BDO, and all these other officers they are appointing.
Okay, so the chief metropolitan magistrates are mostly in union territories, whereas the DM or DC is the designation in the states. Is it okay? Is it fine?
Yes.
So as far as the CMM is concerned, the CMM is mostly in the union territories only.
In Hyderabad, in some other states are also there. Kanpur, there is a CMM. Hyderabad, there is a CMM. Might be Bangalore. I'm not sure. In other
that may be CJM.
No, CMM is also there, sir.
CMM is also there.
Hyderabad, Kanpur. So they are also appointing court commissioners. Means advocate commissioners as a commissioner.
So this is the matter where the matter was matter that came in consideration before Honorable Supreme Court, whether the ambiguity and conflicting views over appointment of advocates as commissioner in order to assist the DM or CMM to secure the possession of the secured asset for executing an order passed under Section 14(1) of the SARFAESI Act. The issue arose as Honorable Bombay High Court on one side and Honorable Courts of Kerala, Madras, High Courts of Kerala, Madras, and Delhi on the other gave different views. Now, issue involved whether it is open to the district magistrate, DM or CMM to appoint an advocate and authorize him or her to take possession of the secured assets and documents relating thereto, and to forward the same to the secured creditor within the meaning of Section 14(1) capital A of the SARFAESI Act. The relevant provisions relied upon, again, Section 14, the district magistrate, that we've already read that. So those are the relevant provisions. So the Bombay High Court in this case, in fact, observed in the case of Subir Chakravarty versus Kotak Mahindra Bank, the Bombay High Court observed, strictly construed the provisions and held that Section 14(1) capital A of the SARFAESI Act, the DM CMM cannot authorize an advocate to secure the possession of the secured assets for executing an order passed under Section 14(1) of the SARFAESI Act. As the language used in the provisions clearly state that such delegation must be done only to an officer subordinate to DM CMM, and an advocate is not an officer subordinate to DM CMM. The Bombay High Court also rejected the argument put forward relating to the overburdened offices of DM CMM leading to shortage of manpower. On the other hand, observations of the Honorable High Court of Kerala in the case of Muhammad Ashraf and others versus Union of India was, ruling on the same was on the contrary, that the Honorable High Court of Kerala held that power lies with the magistrate under Section 14 of the SARFAESI Act to take the aid of the police, including an advocate commissioner for securing the assets of a secured creditor. Now, let us see what exactly was the observation, what was held by Honorable High Court of Madras in the case of S. Chandramohan and others versus CMM, and similar to the view given by Honorable Kerala High Court, the Honorable Court held that post insertion of Section 1 capital A to Section 14 via amendment of 2013, which Section 14(1)A permits the subordinate officers to take possession of the assets and documents relating to secured assets of the secured creditors, and to forward such document to the secured creditors. And nowhere prohibits the CMM from authorizing an advocate commissioner to go on his behalf for taking possession of assets and documents and forwarding the same to the secured creditor. So the Madras High Court said there is nothing, no prohibition. Kerala High Court said the same thing. However, the Bombay High Court gave a conflicting view, and then even Delhi High Court also said that the section 14(1)(a) does not bar the appointment of advocates. Now let us see what Supreme Court says. In fact, this was various things the Supreme Court have said, which is so. Ankit, would you be able to see exactly what Supreme Court said, and would you be able to read for the purpose of all the?
So the Supreme Court said that the statutory obligation it enjoined upon CMM-DM is to immediately move into action after receipt of a written application under Section 14(1) of 2002 Act from the secured creditor for that purpose. It is common knowledge that the respective jurisdictions where there is only one CMM-DM, if he is expected to reach at every location himself for taking possession in some jurisdictions, it would be impractical, if not impossible, for him to do so owing to large number of applications in the given jurisdiction being a commercial city. While entrusting the act of taking possession of secured assets subsequent to the order passed under Section 14(1) of 2002 Act to any officer subordinate to him, CMM-DM ought to exercise prudence in appointing such person who will be capable of executing the orders passed by him. Merely because he has power to appoint any officer subordinate to him, it would not permit him to appoint a PN or clerk who is incapable of handling the situation. It is well established that an advocate is a guardian of constitutional morality and justice equally with the judge. He has an important duty as that of a judge. He bears responsibility towards the society and is expected to act with utmost sincerity and commitment to the cause of justice. He has a duty to court first. As an officer of the court, he owes allegiance to a higher cause and cannot indulge in consciously misstating the facts or, for that matter, conceal any material facts within his knowledge. As an officer of the court, he is under a higher obligation to uphold the rule of law and justice system. An advocate is an officer of the court and thus subordinate to CMM-DM. Hence, it would be open to CMM-DM to appoint an advocate commissioner to assist him/her in execution of the order passed under Section 14(1) of 2002 Act. So basically, Supreme Court has basically said that it is okay, advocates can be delegated the duties which are specified in the system.
So all these measures will definitely speed up, will help in disposing of such a huge pending cases before the DM and CMM. The one more, sir, as per my opinion, two more practical difficulties which DMM, CMM face, that they officially do not get any fee for this process, and they have to dispose their duties. Although in some cases there is a fee for magistrate and police, but in most of the cases, state directly doesn't get any fee for issuing the orders. Indirectly, they may get help when the borrower defaulter deposits the recovery. But yes, maybe due to this, volumes are increasing. So we can go to next judgment, sir.
I think this is a good addition that you are doing, that there is no fee to the state government. But I feel that when they appoint advocate as commissioner, then they allow them to take some fee.
Yes, but advocate, I suppose that there is I think there is a personal fee for them.
That is only for them.
Yeah, for them only.
So now we have this Indian Overseas Bank versus RCM Infrastructure Limited. The judgment was delivered in May 2022 by Honorable Supreme Court, and this is regarding the loan. Like, let me say first of all the facts, and this is something where in fact, this is a case where SARFAESI Act and insolvency law, they in fact came together, and the court finally held that the IBC is overriding the provisions of SARFAESI Act. So in this case, the loan was taken by the company and it was classified as NPA. Demand notice was issued, and the properties in any case was supposed to be e-auctioned. So everything was done, and the property was in e-auction. In the meantime, the company filed an application under Section 10 of IBC before NCLT. And in the meantime, the banks were trying to sell the property, and they in fact found a customer and they confirmed the sale to the customer, and the customer paid 25% of the public auction bid. And the bank also issued a sales certificate to the customer. Subsequently, when this NCLT admitted the petition under Section 10 of the code, as a result of the said order, the moratorium started. Appellant filed its claim in claim form, like the bank also, the secured creditor filed its claim in Form C with the IRP according to the appellant, since the balance 75%. So he only filed a claim for 75% of the bid amount, which was so far not received by him. This was the claim filed by the bank. Now, during the pendency of the CIRP, while this moratorium was on, the balance 75% was also received by the secured creditor. And then he revised his claim that I have received this amount of 8 point some crore, and the claim was also revised in this regard. So therefore, the promoters filed this application praying the NCLT to set aside the security realization during CIRP period. And in fact, the NCLT allowed this said application, and then there was an appeal filed before NCL 80, and the NCLT also rejected. And now the issue with the Supreme Court was whether a bank can continue the proceedings under SARFAESI Act once the CIRP is initiated and moratorium is ordered. So in this case, the Supreme Court has observed what is the intent in the moratorium under Section 14 of IBC. Now, the Supreme Court says after initiation of CIRP, there is moratorium for any action to foreclose, recover, or enforce any security interest created by the CD in respect of its property, including any action under SARFAESI Act. Once CIRP is commenced, there is complete prohibition for any action to foreclose, recover, or enforce any security interest created by the CD in respect of its property. The words including any action under SARFAESI Act is significant because these were the words in the IBC. The legislative intent is clear that after the CIRP is initiated, all actions, including any action under SARFAESI to foreclose, recover, or enforce any security interest is prohibited. And Section 238 also said it is overriding other laws. The security realization during CIRP period, the provisions of Section 14(1)(c) of the code, which have overriding effect over any other law, any action to foreclose, recover, or enforce any security interest created by the CD in respect of its property, including any action under SARFAESI, is prohibited. So the arguments, in fact, was made, like the Transfer of Properties Act were also appellant said the Transfer of Properties Act says that the payment was made. It was subsequently, because now the transaction cannot be undo. The respondent also say that it is a statutory sale. But finally, the Supreme Court says that the CIRP is commenced, moratorium kicks, and there is a complete prohibition for any action to foreclose, recover, or enforce any security interest. Further, Supreme Court says that if the words including any action under SARFAESI Act are insignificant, the legislative intent is clear that after the CIRP is initiated, all actions, including any action under SARFAESI Act to foreclose, recover, or enforce any security interest is prohibited. As per Section 238 of the Code, the provisions of the Code would prevail, notwithstanding anything inconsistent therewith contained in any other law for the time being. The appellant bank could not have continued the proceedings under the SARFAESI Act once the CIRP was initiated and moratorium was ordered, the bank cannot continue the proceedings under SARFAESI Act once the CIRP was initiated and the moratorium was ordered. So this was the Supreme Court judgments, 3 Supreme Court judgments that we've discussed. One talks about the tenancy and whether there is any right with the DM or CMM regarding handling the tenancy matters. Second, the authority of the subordinate officers like the additional DM or additional CMM, and also the further is the whether the advocates to be appointed as commissioner. That also ambiguity has been now cleared. Further, the SARFAESI prevails over IBC, and even if 25% has been taken and the sales certificate has been issued, since the 75% was recovered during moratorium, that is not something which is as per law. This is finally was held by Honorable Supreme Court. Ankit, I think you can take up the judgments which has come from High Court.
Yeah, so Honorable High Court judgments include, let's start with this Jalgaon Janta Sahakari Bank versus Joint Commissioner of Sales Tax Nodal 9 Mumbai. It's a Bombay High Court judgment from dated 30th August 2022. So the controversy in this case lies in narrow compass with SARFAESI and Recovery of Debt and Bankruptcy Act. Then the question was that who between a secured creditor and the taxing revenue department of the central state governments can legally claim priority for liquidation of their respective dues. Q are the borrower dealer upon enforcement of security interest and consequent sale of the secured asset. So there were 2 banks involved in this case. Both banks said that they have a claim over the priority or have priority over the liquidation, and that's what is handled in this judgment. So these similarly worded sections, so it talks about how similarly worded sections starting with a non-obstant clause provide that any amount of tax, penalty, interest, sum forfeited, fine or any other sum payable by dealer or any other person shall be the first charge on the property. So it is basically how this is the exact sales tax officer judgment that we are dealing with in IBC, and we can understand that how this was handled by the Bombay High Court in case of SARFAESI Act. Let's go forward. So question of law involved is, does a secured creditor have a priority over the relevant department of the government to appropriate the amount realized by the sale of a secured asset? And the second was whether a dispute whether despite section 26E in the SARFAESI Act or section 31B of the RDDB Act, dues accruing to a department of the government ought to be repaid first by reason of first charge created over any property by operation of law, given such dues precedence over the dues of a secured creditor. So 26C, let's understand that first. 26C is part of SARFAESI Act. It says priority of secured creditors. It says notwithstanding anything contained in any other law for the time being in force, after the registration of security interest, the debts due to any secured creditor shall be paid in priority over all other debts and all revenue, taxes, cesses, and other rates payable in the central government or state government or local authority. If I go in and see the date of 26E coming into force, or rather 26E being amended, this 26E I can see was amended . 26 was amended in 2013. So it's a very old amendment. Then explanation for this further includes that for the purpose of this section, it is hereby clarified that on or after the commencement of the Insolvency and Bankruptcy Code, in cases where insolvency or bankruptcy proceedings are pending in respect of secured assets of the borrower, priority to secured creditor in payment of debt shall be subject to the provisions of that code. So wherever IBC is in conflict with SARFAESI, IBC will prevail. But otherwise, SARFAESI says that wherever you are distributing or you are distributing sale proceeds from an asset where SARFAESI action has happened, or wherever you are looking at debts due to any secured creditor, they shall be paid in priority over any government dues. Then priority to secured creditors. So this is part of RDDB Act. Priority to secured creditors again says, notwithstanding anything contained in any other law for the time being enforced, the rights of secured creditors to realize secured debts due and payable to them by sale of assets over which security interest is created shall have priority and shall be paid in priority over other debts and government dues, including revenues, taxes, cesses, and rates due to the central government, state government, or local authority. Explanation to it again refers to the IBC and the overriding provisions of the IBC. So we will conclude together. Let's go on and see what it further says. So observations to question of law in point A and B. It says priority means precedence or going before. So in view of the splurge of first charge, so the interpretation is that first charge is everywhere and it is in multiple litigations now. So the Parliament advisedly used the word priority over all other dues in the Sarfaesi Act to obviate any confusion as to interstate distribution of proceeds received from sale of property of the borrower dealer. The dues of secured creditors shall have priority over all other, including all revenue, taxes, and so on. Section 626C therein has to explicitly make the valuable right of the first charge holder subordinate to the dues of a second creditor. So basically, where the state government or the central government under the GST Act, under whatever act has a first charge under those non-obstant provisions, then non-obstant provisions will, these provisions or this RDDB Act and Sarfaesi Act will override those provisions. Then the RDDB Act and the Sarfaesi Act are central acts. Now here the comment is on basically how central acts and state acts will coordinate, because in case the state legislation says that okay, we will have these dues recovered as first charge, what happens in case a central act says that this needs to be overridden? So there the reference is brought to Article 254 of the Constitution, which contemplates the principle of repugnancy, where it says that any act which is in any central act which shall prevail over the state legislation. So that priority which is available in the Constitution with respect to central laws over the state laws is something that has been brought here. So question of law involved were the provisions inter alia according priority in payment of dues to secured creditor for enforcing its rights, interest under provision of Sarfaesi Act prospective. So the question next was, the third question was, these rights are prospective or not? So the right of enforcement securities 26D, it said notwithstanding anything contained in any other law for the time being enforced from the date of commencement of the provisions of this chapter, no secured creditor shall be entitled to exercise the right of enforcement of securities under Chapter 3 unless the security interest created in its favor by the borrower has been registered with the central registry. So coupled with the express provisions in Section 26D regulating the exercise of powers by secured creditor by barring them to take recourse to Chapter 3 without per se registration, there could be little hesitation to hold that 26E is prospective, because since 26D kind of gives a power, so it kind of, the code used 26D and the language therein to interpret that the date of implementation or date of making this effective would be 26E, and I have shared that the date is 2013. Exact date is exact date of these modifications coming in were 15/1/2013. So let's go forward.
Can you just practically tell the audience that are the taxes are being claimed under Sarfaesi Act? How many disputes are pending?
I will talk about that after this slide. So whether Section 31B of RDDB Act can be pressed into service for overcoming the disability that visits a secured creditor enforcing its security interest under Sarfaesi Act upon such creditor's failure to register the security interest in terms of the amendments. So here the observation of the court was that a secured creditor finding it is disabled from obtaining the benefits of priority in terms of Section 26C of the Sarfaesi Act for want of per se registration cannot fall back on Section 31B of the RDDB Act to claim priority. So Section 31B of RDDB Act being a substantive provision, it cannot be invoked by a secured creditor facing with a disability posed by Section 26E of the Sarfaesi Act. So without recourse having been taken to the procedure envisaged in RTDB Act for recovery of its dues, and without there being a determination of its claim by DRT to the effect that any sum due from borrower is payable to it, the secured creditor is not entitled to invoke the provisions of 31B. So basically, this fourth question was basically that if some bank or some financial institution fails to do a SARFAESI registration, can they bypass that miss that they have done in complying with the 26E to go to 31B and still claim that they have a priority? So there the court said no. In case you don't have a SARFAESI registration, then that priority cannot come to you. Let's go forward.
In many districts now, the DM is taking this proof of SARFAESI registration along with the application of Section 14.
Yeah, so that's basically to make sure that ensure that no other security interest will be in priority to the security interest of the bank in any case whatsoever, even where the state government has not come to the doors of the DM at that stage.
Yes.
So that's there. Then the fifth question is whether
yesterday when I met the managing director of NESL in that 6th annual function of IBBI, he said that now the information utility that we have prepared, IU, so most of the claims have come. So it is advisable that whenever a case is, whenever CIRP is commenced in any cases, the RP should first go and see how many people have already filed claims in that matter. So that is a ready list available regarding the claim on a particular company.
So that's important. But then more than that, I think SARFAESI is also something that we can do, because we have done that in the past. SARFAESI offers a property address based search. So in case the property address has now become available to the RP can spend some 10-15 rupees and do a search on SARFAESI database for that property, where he can find out what are the charges registered in SARFAESI by various authorities against that property. So that's also something that can be added in the things to do, because in case SARFAESI registration is there, then that helps. So let's complete that last slide before. I think we'll have to do a part 2. We are already at 2.7, but we will wind up this judgment. Whether the priority of interest contemplated by Section 26E of SARFAESI Act could be claimed by a secured creditor without registration of security interest with central registry. Section 26D prohibits a secured creditor from exercising the rights of enforcement of security interest unless it is registered with SARFAESI. So not only registration with SARFAESI has been made a mandatory precondition for invocation of the provisions contained in Chapter 3, the provisions relating to debt that are due to any secured creditor being payable to such creditor in priority over all other debt and revenue, tax, etc. is available to be invoked only after the registration of security interest. So this being the text of 26E, which is to be read in context in which it is set, leads to the irresistible and inevitable conclusion that unless the security interest is registered, neither can the borrower seek enforcement nor does the question of priority in payment would arise without such registration. So now looking at this, now I think we can have a brief understanding that what happens to sales tax officer after we understand these provisions of SARFAESI Act. So either this kind of a provision will now be inserted in IBC, which will again give clarity that how things will shape, because in case this priority is not available to secured creditors, then secured lending will kind of cease to happen over the years to come in case of defaulting entities, or in case because the default of entities would immediately lead to first charge by the government.
What so far we have seen that the under SARFAESI Act also there is no priority which is given to any kind of government revenue or taxes. But the only condition is that under the SARFAESI Act, which was also a condition imposed in 2016, and I think some of the conditions were also in 2019, when the SARFAESI was made mandatory. Registration with SARFAESI was made mandatory. Now I think we can conclude that the law is that if any mortgage is registered with SARFAESI, then there is no lien charge, or there is no dues which are related to taxes and the government dues would not be paid. So the similar is the case with the IBC, unless the assets are attached by government authorities, because it's state tax versus state tax officer versus Rainbow Papers Private Limited. The very important facts are that the recovery process started much before CIRP, and the assets were also attached during CIRP, although that was something which was not detailed by Supreme Court. But then, yes, to my understanding, this issue is clear that the tax, in case unless the assets are attached. Ankit, I think this is the last one. We can read this and we can complete this SARFAESI judgments today. Maybe it takes 5-6 minutes.
Sure. So Dena Bank versus Siddhartha Pulses through proprietor and others. This is September 22 judgment from the Bombay High Court. So petitioner bank made available cash credit facility of 4 crores to the respondent number 1, Siddharth Pulses. I think there are okay. So so here in to summarize in this
you
case,
can take, in fact, there are 2 more judgments. I think we can take part 2 also.
Yeah, we can do part 2 because otherwise it will be too lengthy. And
Yeah.
what we can do is we can maybe add some more case laws so that we can have an hour session next time.
Right. So I believe, we can actually, from Dena Bank, we'll start afresh in the next session. And also we have to announce that the next session would be on Saturday. It is not going to be on Sunday because it is 90th birthday of my mother. So we are celebrating during lunch hours. So we would be having the next session on Saturday at same time, which is 1 o'clock, Ankit?
Yeah, 1 o'clock, same time.
Same time, 1 p.m. We will have it on Saturday. So anything else that you would like to add, Sanjay?
Right, sir. We can add some more judgments in the part 2. Few more judgments have come, but the SARFAESI Act is being now more streamlined by these kind of High Court and Supreme Court judgments. The need is that banks need to take up the issues with the banks wherever they feel difficulty, maybe through agents, maybe through advocates, maybe through contempt applications. So this will help the banks more in recovering their due. So this is a nice discussion today, sir. We have correlated these judgments. Yes.
Thank you very much. We'll have more judgments and we'll conduct this part 2 for SARFAESI judgments and importance of these SARFAESI judgments. Saturday, 1 p.m. Thank you very much, all the participants. And we again will do this collective learning. And as I always say, that this is our way of learning. Thank you very much. Thank you.
Thank you, everyone.
Thank you, everyone. Thank you.